Allahabad High Court APS Series A, Exercise 30 at the speed of 110 words per minute. Be ready? Start. The challenge in these appeals is to the analogous judgment and order dated 25/6/2019 in the first appeal number 81 of 2017 and first appeal number 82 of 2017, whereby the High Court of Uttarakhand had allowed both appeals by reversing the common order dated 4/7/2017 of the Family Court Dehradun. Before the Family Court, the appellant succeeded with his case for dissolution of marriage, but the respondent failed to secure a favorable verdict in her petition for restitution of conjugal rights. Stop para. The appellant is an army officer with MTech qualification. The respondent is holding a faculty position in the government PG College, Tehri with PhD degree. They got married on 27/9/2006 and lived together for few months at Vishakhapatnam and at Ludhiana. But from the initial days of married life, differences cropped up, and since 15/9/2007, the couple have lived apart. Stop para. Following the estrangement, the appellant earlier applied for divorce from the family court at Vishakhapatnam. The respondent then filed a petition against the respondent in the Dehradun court for restitution of conjugal rights. Later, when she learnt of the case filed by the appellant at Vishakhapatnam, the respondent filed transfer petition (C) number 1366 of 2011 before this court. The appellant appeared before the Supreme Court and stated that the case at Vishakhapatnam would be withdrawn. This court then recorded the following order: para. Counsel for the respondent states that the respondent would withdraw his petition pending before the family court at Vishakhapatnam, Andhra Pradesh, and in case he has to file any petition seeking any relief against the petitioner his estranged wife, he will file the petition only before the proper court at Dehradun, Uttarakhand. In view of the statement made at the bar, the petitioner is left with no grievance. The transfer petition is disposed of. We may, however, observe that in case the respondent files a petition at Dehradun, the Dehradun court shall take it up and dispose it of expeditiously and without any undue loss of time. Stop para. For considering dissolution of marriage at the instance of a spouse who allege mental cruelty, the result of such mental cruelty must be such that it is not possible to continue with a matrimonial relationship. In other words, the wronged party cannot be expected to condone such conduct and continue to live with his/her spouse. The degree of tolerance will vary from one couple to another, and the court will have to bear in mind the background, the level of education, and also the status of the parties in order to determine whether the cruelty alleged is sufficient to justify dissolution of marriage at the instance of the wronged party. Stop para. When the reputation of the spouse is sullied amongst his colleagues, his superiors, and the society at large, it would be difficult to expect condonation of such conduct by the affected party. The explanation of the wife that she made those complaints in order to protect the matrimonial ties would not, in our view, justify the persistent effort made by her to undermine the dignity and reputation of the appellant. In circumstances like this, the wronged party cannot be expected to continue with the matrimonial relationship, and there is enough justification for him to seek separation. enough justification is found to set aside the impugned judgment of the High Court and to restore the order passed by the family court. Stop.